Morning, ladies and gentlemen. We'll get us started here. If I could call on Judge Scoggins to open us up, please. And what number are you?
I don't think this one works. That's right.
Yeah, 16.
Got it? Yeah. Okay, let's pray, please. Our most kind and gracious Heavenly Father, thank you for the day to be here and do the work on behalf of the state of Georgia. We thank you for everything that you do for us each and every day, and we know that we depend on you for the best things that we can do. So I ask you to pray for us, and I ask you to lead us and guide us through this prayer and through this work we're going to do today on behalf of the state of Georgia. Be with us throughout the day. In God's name we pray. Amen.
Amen. Thank you, Judge. All right. The Senate Bill 347 is off of the calendar, so if you're here for that, we'll not be hearing anything on that bill today.
Is that, which one is that?
So that brings us to Senate Bill 425. Is the author here or somebody here?
He is not, Mr. Chairman.
Oh, okay. I'm sorry. Go ahead.
Chairman Tillery, I believe, is attending to the state budget with Chairman Hatchett and others, and I'm proud to present Senate Bill 425 in his absence. We are working off LC 0569S, so if anybody does not have a copy of that who wants to get it, I believe we may have some extra copies of it. But as you can recall from a few weeks ago, this bill is a follow-up to some efforts in the past to deal with electronic technology on closings, and we're trying to find a way to move Georgia forward in the digital age while retaining our attorney-only closing system here in Georgia, which has served Georgia well, but is unique nationally. There are constant efforts to try to take that away from Georgia, and that's not something that Georgia has wanted to do. Technology's changed, and this bill is supported by the Georgia Real Estate Closing Attorneys Association as well as the Georgia Association of Realtors. The bill allows for remote electronic notarization for nearly everything, such as articles of incorporation, custody agreements, powers of attorney, but it also allows for in-person electronic closings for real property. However, that is not required. That is a new permanent option. As you may remember, during COVID, there was an electronic component temporarily. This gives a permanent electronic option on closings, but it is not required. So you can continue doing closings the way you have under Georgia's Supreme Court rules. So the bill codifies existing Supreme Court rules on the conveyance of real property and the unauthorized practice of law, essentially the series of events in the closing of real property in Georgia. And I want to be clear about that. It doesn't require electronic closings for any type of closings. For an electronic component to occur, all parties to the transaction must consent. I know that there are many people in the room and many people who do closings who want to keep it the way it is, and you can continue doing that as long as it complies with the law. The bill would still allow for that, but it would add an electronic component if all parties consist. I want you to imagine if you went and closed your house, which for most folks in Georgia is their biggest asset, and when you go to sell it, somebody out of state in Detroit, they closed it, and there are improper things, and your main asset is tied up, and now you have to contact a 1-800 number to try to straighten it out. What this bill does is it makes sure there is a Georgia lawyer who, where the buck stops on a closing forever in Georgia. That's the way it is now, and that's the way it should continue to be. Other states may want to have the 1-800 number in Detroit, but that's not right for Georgia closings. This will move Georgia in the digital age and also facilitate us continuing to be the #1 state to do business. Here are the mechanics of the bill. Again, we're on LC 0569, and I'd like to acknowledge good work by Whip Burchett on this the last several days, working with Chairman Tillery. And again, you have e-notary on things except for wills, trusts, and real estate, but it allows for in-person electronic notarization for real estate transactions. Specific changes from what you saw last time a few weeks ago are on line 36 it adds quote or interest in end quote for leasehold transactions. On lines 59 and 61, it changes the definition of real estate closing to apply to all closings, residential and commercial, because that's consistent with the Supreme Court opinions cited in section 1.1 and discussed last time. The advisory opinions use the term real property with no distinction between residential and commercial transactions. And I know some people are here to testify about today, and you will be heard on that. Line 66 and 67 allows for in-person electronic notary for real estate closings, which adds an ability to use electronic means if all parties consent. Lines 91 to 128 removes various requirements and mechanisms for a remote closing, adapting them to in-person electronic notary. Lines 264 to 288 adds some language synced up with Code Section 45-17-6 that clearly states an electronic notary is allowed for, and the requirements to be included, such as the notary's name, the name of the state, the county of appointment. And something that's come up this morning, there is some heartburn about mail-away closings. Even if you've got a Georgia lawyer who's drafted the documents and who was in charge of the closing, some commercial real estate lawyers are concerned about the ability to do a mail-away closing. I want to point to lines 299 to 303 of the bill, which I'll read for anybody who's not here in the room. Nothing in this code section shall invalidate an in-person notarial act performed in the physical presence of the notary public that occurs in another state that complies with such state's regulations for an in-person notarial act to be performed in the physical presence of the notary public, or a notarial act that occurs outside the limits of the U.S. that complies with the provisions of Article 2 of this chapter. So this bill does contemplate and codify authorization for a mail-away closing, which occurs when there are parties to the transaction who are in California or Arizona or Detroit or New York City or some other state. But it makes it clear that there needs to be a Georgia lawyer who's drafting the real estate instruments and who's in charge of the closing. We want that to be clear to everybody. And again, we added an electronic component. So that is the current version of Senate Bill 425, requested by our Senate Appropriations Chair, Blake Tillery. And thank you, Mr. Chairman.
All right, Chairman Smith.
Thank you, Mr. Chairman. Good morning. Thank you, Vice Chairman, for doing such a great presentation. Just a real quick question. Under this bill, would the technology provider be guilty or liable if a third-party notary who used that platform and committed this fraud? I mean, I'm sitting here thinking of a scenario about how this would be different than making QuickBooks or TurboTax liable when someone else is actually committing the tax evasion by just using their software. That's just a concern that, you know, I had pointed out, and I just wondered what your take on that would be.
My take on it is the bill is better than it was when it passed the Senate, when it was back before us last time. But the reason we got a House Judiciary Committee is to do work like that. I've heard this morning from some people who saw that language, and I'll leave it up to the work of the committee. I know Chairman Tillery doesn't like amendments, and I don't blame him on that, but that technology line item is something that I have heard some concerns about.
Yeah, and thank you. And I hate to ask you these questions because I know it may be out of your purview, but I think the question still begs to be asked. What's wrong with the version that this committee, in its wisdom, passed out before?
I know that Whip Burchett, who's on Rules Committee, took another look at this and worked with the Senate Appropriations Chair and made a lot of amendments to it. So this is a different bill that took into account a lot of the feedback that was given at the last hearing and otherwise.
All right, I don't see any other questions. There are some people, by the way, if you want to speak on this bill and you haven't signed up, I have a sign-up sheet here. We got that out late. But I will take some testimony, but it needs to be brief. I've got at least 2 members headed to Senate Judiciary, Senate Rules to take care of some bills that they have up there. So I'll give you a chance to sign up if you still want to. Anybody? All right. Then I'll call Jim Jordan. Good morning.
Good morning, Chairman, members of the committee. Glad to be back before you to speak briefly about this substitute bill. Partner, commercial real estate lawyer and partner with Evershed Sutherland, a member of an informal working group of commercial real estate attorneys that have been working in good faith on this bill for 2 months to protect the residential closing process without unduly burdening the commercial real estate closing process. Our concern is that this bill change from the bill that was passed at this committee 2 weeks ago tomorrow to change the language that limited it to 1 to 4 family residential real property transactions. So it now applies to every real estate transaction. We don't want to protect the closing attorney in Detroit that Representative Reeves mentioned in his opening comments. That isn't our concern. We're also totally in favor of remote online notary process. We'd like that. That's not a problem. The problem that I have, is that this bill does not, in my opinion, permit commercial real estate closings to occur as they've occurred during my entire career and as they're occurring today somewhere in Atlanta and will be tomorrow and will be after June 1st. Representative Reeves mentioned lines 299 to 300, 303, I think. Those lines are limited to the notarial process. They talk about that out-of-state notarization can occur, and that's great. That's the law, and we're all in favor of that. The concern we have instead, I'll tell you what the concern is, and I'll tell you what our specific request is, and then I'll yield the floor to whoever else wants to speak on this. The concern we have is line 79, which is new law. This is new provision. It's not in the Georgia Code now. It says an attorney conducting any real estate closing shall, 1, be licensed and present in the state at the time of the closing. I mean, the problem is that a commercial transaction doesn't have just one closing attorney. There may be 4 or 5 or more closing attorneys involved in the closing process. There is a Georgia attorney who drafted all the documents in accordance with Georgia law. That may be me in a transaction. I represent an in-state party who is developing a shopping center, let's say. There may be an out-of-state lawyer involved representing a lender. There may be an out-of-state lawyer in New York or Charlotte, North Carolina, representing an equity provider. And we all collaborate in the closing, and then we use a third-party escrow agent, which is permitted by the rules of and the opinions of the Supreme Court, where you can delegate administrative and functions to third parties. A lawyer doesn't need to be involved in every process as long as we're supervising the entire process from start to finish, which we do through a variety of mechanisms, including an escrow letter we send to the escrow agent saying you can close the transaction when A, B, C have happened. We've approved everything, and we tell you that you can close. But we're not involved directly in that process. We use agents as permitted by the Georgia Supreme Court rule. So the concern I have is that law would unintentionally sweep into violation and felony violation, I will note, out-of-state attorneys that may be involved in the closing, even though there's a Georgia real estate lawyer involved in the closing. There may be multiple Georgia lawyers involved in the closing transaction, but there isn't just one attorney. So that's the problem we have. Even if it is, and it may well be that every transaction that we, with these mail-in closings, would be an electronic closing, because if you look at line 65, it defines a real estate closing using electronic means as any transaction in whole and part using electronic means. Every transaction I close involves in whole or in part electronic means, because there are emails sent, the wire is done, nobody shows up with a suitcase of cash at a closing, the funds are wired in electronically. So I think the concern definitionally is that every transaction would be a real estate closing using electronic means, and we'd need to comply with this Teams or Zoom approach, which I've never seen employed in a transaction in my career. So I think this is a big problem. I think it's going to affect very much what commercial real estate lawyers do. It's going to affect very much the commercial real estate transactions that occur on a daily basis in this city and that drive the growth of this city. So our specific concern is similar to the language that was in the bill that was passed by this body 2 weeks ago, would be to add back on lines 59 to 61. So add back the words 1 to 4 family residential in both places. That's imperative, in my opinion, to make this work from a commercial real estate lawyer's perspective. And then we also had circulated language we'd like to have that says requiring a closing disclosure under the Consumer Financial Protection Board requirements, which essentially is the HUD 1 requirement that you had suggested, Representative Reeves, last time. So those are the suggested changes that I think we really, really need from a commercial real estate lawyer's perspective, would be to add back 1 to 4 family residential in lines 59 and 61, and add the requiring a financial disclosure pursuant to a federal law. And with that, I'll pass, but I'm happy to answer any questions.
You have several here. Hang on just a second. Representative Kelly.
Thank you, Mr. Chairman. Mr. Jordan, thank you for being here with us. If we insert 1 to 4 residential on 59 to 61, as you suggested, would that get the commercial closers? Would y'all be in support of the measure then?
We'd be closer to being in support. I mean, I would prefer if the alternative is that language, the only option is that language or nothing, then I'll take that language.
And you'll support the measure?
I would personally. I can't speak for anybody but myself.
Maybe y'all could huddle up before we consider any amendment.
Thank you.
We'd like to, if we're gonna make changes for a group, then the group needs to be supportive once we make them.
Okay, thank you.
All right. Chairman Smith.
Mr. Jordan, good to see you again. Enjoyed speaking with you and reasoning together last committee meeting. On lines 109 to 115, my question, since you're a learned attorney and you've been practicing a good little while, I'd imagine, your thoughts. I mean, that could it not result in limitless or boundless accessory to the fact the way that's written?
Yeah, I think it could, Representative. And you mentioned the technology provider in one of your earlier comments, aiding and abetting. So anybody who's involved in a closing which doesn't comply with these requirements, because there are a lot of technical requirements in terms of how the Zoom or the Teams call occurs and retention of records and all sorts of things. But anybody who is involved in that process that went awry due to some technicality runs the risk of willfully and knowingly aiding or abetting another person and being liable for a felony. I think that that the big Microsoft that runs Teams and Zoom and all these people that provide the technology that will be relied upon for those electronic closings could be at risk. I agree.
Okay, thank you.
And I think it's Representative Evans.
Thank you, Mr. Chairman. Thank you, Mr. Jordan. I was wondering if on line 77, your concerns might be alleviated if we just changed an attorney to at least one attorney. So that way you could have this team, but as long as one person was a Georgia attorney and they're in charge of the supervision process, that might alleviate your concerns. And I was wondering if I was correct about that.
The only concern I would have would be because we do it through an escrow process as permitted by the Georgia Supreme Court opinion. How about if I'm in Florida at my condo and I'm doing a closing, I'm working over the weekend and I'm doing the closing down there. I'm not resident in Georgia, but I'm handling the closing. Why do I have to be sitting in my office in Atlanta? Remote work is certainly what happens. 3 days a week in a lot of law offices these days, sometimes in Atlanta and sometimes out of the state. But as long as I'm doing my job, why do I have to be sitting in Atlanta somewhere or in Georgia?
Okay, so it wouldn't help you.
It would help.
Okay.
But it wouldn't solve the problem.
Thank you.
Representative Leverett. Excuse me.
Thank you, Mr. Chairman. Good morning. Just to Representative Evans' question, I would assume it's seldom that you're the only one in your firm working on a closing that you would handle. Is that fair to say?
Usually it's a team often. Yeah, it may be a paralegal who's not an attorney. It may be me and a paralegal handling a transaction.
Okay. So so that really wouldn't help us, I guess. I was thinking most of the time, I would assume the nature of the transactions you're handling are ones that you just don't carry the load all by yourself.
Correct.
And so even if you are at your condo in Florida, you probably got somebody, some minion back in Atlanta who would be present during the transaction, I would think.
We call them younger colleagues.
Yes, I understand. Out in the hinterlands where I'm a sole practitioner, I call them minions, but I mean it in the most positive sense of the
I
word.
understand.
All right, well, thank you. That was just something I was curious about. Thank you, Mr. Chairman.
All right, now that I've recovered. I don't see any other questions. Thank you, sir.
You're welcome.
Who's next? Joe O'Kelly and Kate Hoskins, I think. See, I'm gonna turn on both of those mics so that y'all have them there. Floor is yours.
Thank you, committee, chairman. I'm Kate Hoskins. I am a partner with the law firm of O'Kelly and Sorahan. Practiced residential real estate for about 21 years. I've been a past president of the Georgia Real Estate Closing Attorneys Association and member of the executive committee of the Georgia Bar Real Property Law section. And
I'm Joe Kelly. I think we've done a lot of work. I'm from O'Kelly and Sorahan, and thank y'all for having us this morning. I'll start. I think when this bill, the general purpose of it was Georgia is the 45th or 46th state. We need electronic notarization. So that's really what this bill was to bring. At the same time, we wanted remote transactions. And if you're going to have electronic notarizations where you can click from any state and do closings, we needed protections and penalties. And so the Supreme Court opinions are currently the law for all lawyers. And so we already follow those laws. I understand some of the concerns, Mr. Jordan, and we don't have an issue with the 1 to 4, but really this is not about lawyers. This is not about trying to nab lawyers or technology providers or anything like that. This is more, there are out-of-state companies that sometimes in a refi boom might do 1,000 closings a month in Georgia. And so when you open it up to an electronic world, it just gets easier, okay? And so that the whole point of it was to codify what's already the law for us and what should be the law for the rest of the country and say, look, if you're going to do it, you need to have some penalties. That's really all that's about. So if we're not following the Supreme Court opinion now as lawyers, or if anybody's not, there's nothing new in here, not one single thing. Now, as far as being in Georgia, I'll just stress that particularly. When you do the settlement, I've done settlements where I did 4,000 homes, one settlement, multi-state. I understand how that works, but I was in Georgia. That's really what that means. I gathered all the documents. I assembled, I controlled them, and then I adopted them. So, and then I did the settlement. Whether I used a title company or whether I didn't, it doesn't really matter. It's all a series of events. So it's not sitting at a table. That's the silliest thing I've ever heard as far as how this goes, as far as what Georgia attorneys are supposed to do. Okay? Did I
we're
miss anything?
codifying directly from the UPL opinion and the formal advisory opinion of the Supreme Court 00-3, where it says the court made it clear that in order for an attorney to avoid committing the unauthorized practice of the law, the lawyer must be in control of the closing process from beginning to end. And it talks about the interconnected series of events. So when the word real estate closing is used in the law, it's not the ceremony of sitting down with signing of the people. It's the interconnected events from start to finish that an attorney who is located, who has a nexus to Georgia, who is located in Georgia, needs to be in control of that, adopt it, and be responsible for it should there be something go wrong and the parties call and need somebody to fix something, which is the way it's worked very well in Georgia all these years.
Okay. All right. I have a couple of questions for you. Representative Evans?
Thank you, Mr. Chairman. When you said that if you're following the law now, this bill is not going to create any problems for you, are you referring to commercial real estate attorneys as well, or just residential?
I actually am commercial.
Okay.
I mean, the law is not written to where you sit down at a table, and that seems to be the issue. And that's not the issue at all. The issue is control. And so you want to have a Georgia-based attorney. You don't want a Georgia attorney that's in Maryland closing loans all day for Georgia properties. That's all that really is. So it really shouldn't affect them as far as their 1 to 4 family request. We don't have an issue with that. But it doesn't really change the Supreme Court opinion. But it does put it in a statute, and if that makes the commercial real estate group okay, it's okay with us. And when I say us, I'm talking about thousands. I'm not talking about 10 law firms downtown. I'm talking about hundreds and thousands of people. And so in these definitions, the reason that you can't add something like a closing disclosure or something like that is that opens up all these closings that do occur for the rest of the world that are not commercial. It opens up cash closings and investor type closings to non-lawyers. So by opening that window, you literally are opening up 30% of our business to outside national companies. Okay, so unintended consequences, yeah. By doing something like that, you really break our back. And so we can't have that. The 1 to 4 family, fine. But anything more than that would be a mistake. Thank you.
Do you have anything? No? That's all the questions. Thank you.
Okay, thank you.
Sean Tidwell?
Good morning,
Good morning.
Chairman, members. Thanks for having me today. My name's Sean Tidwell. I'm a lawyer licensed in Georgia. I've been working here 21 years doing commercial real estate. I'm also licensed in Tennessee and worked on commercial real estate for 10 years before that. From the minute we got this bill, I don't know, 6, 7, 8 weeks ago, I immediately realized that there was an issue in 1519-52, Section B. It says, any attorney conducting a real estate closing shall be licensed and present in the state at the time of closing and directly supervise and be responsible for the entirety of the closing. That's just not how commercial real estate deals work. And Mr. Jordan did a great job of explaining this. I work for the title company. I'm the escrow person. I'm licensed in Georgia. We probably have 6, 7 other attorneys that are licensed in Georgia. We're working with the firms that are on the list. I immediately wrote a letter in opposition and got it signed by Evershed Sutherland, King and Spalding, Smith Gambrell, Troutman, Seyfarth, all the big law firms, because we all recognize this could dramatically change the way real estate deals are closed in Georgia. In a commercial deal, what happens is Jim's firm maybe represents a buyer, and there's some other lawyers that have been at the hearings but are all out of town today, unfortunately. And maybe Shelley Willis's lawyer, Troutman, represents the seller. They're Georgia lawyers. They put everything together. They send it to us with an escrow closing letter. Everybody wires us the money because the banks want the money flowing through our $2 billion of reserves in case there's a claim. We sign a letter contractually obligating us to close it the way they tell us. So they're supervising us and how they close it. And then when they tell us to, we close the deal, right? That's the way it's been done the entire 21 years I've been doing it here. I've probably been to 2 in-person closings. I respectfully say that if this is enacted with that wording, without the limitation to 1 to 4 family, we're going to have to either have in-person closings or we're going to have all Zoom closings. It's just not the way it works. I'll give you one example. We're involved in a transaction in Bartow County that's a, $4 or $5 billion Hyundai battery plant. There's no way that people in South Korea are going to get on a Zoom call or fly to Atlanta to close that deal. It would be devastating to the way commercial real estate deals close. Now, if you limit it to 1 to 4 family residential, it doesn't get us all the way where we need to be because there are some transactions like foreclosures or investment properties, or somebody's buying a big plot of land to build a subdivision and there was a house on it at the time. That's a 1 to 4 family dwelling. So there is some problem still if you add 1 to 4 family, which is why we tried to modify the definition. I understand Mr. O'Kelly saying that that could be a problem. So maybe we say consumer 1 to 4 families, right? What we're trying to do here is protect the consumer against witness-only closings, which, by the way, are already unlawful under the Supreme Court rules. But there are no consumer to protect in a commercial real estate transaction. These are sophisticated parties that either have Georgia lawyers or they hire Georgia lawyers to be their local counsel to give them opinion letters, whatever they're doing. So we're not doing anything that's going to hurt anybody else. We're just trying to protect the process, the way commercial closings have been the entire time I've lived in the state of Georgia, so that we don't have to change and have in-person or Zoom closings. That's all we're trying to do. So we are definitely supportive of this bill. If you put in 1 to 4 family residential in the 2 places it was taken out, I believe it was 58 or 59 and 61. It's not perfect for us, but we definitely can support it that way. Really, that's, Mr. Jordan hit all the fine points, so I'm just trying to cut to the chase. We just need it not to apply to residential, not because we're not trying to keep consumers protected, but we don't want to change the way commercial real estate deals close in Georgia. That would be bad for business for Georgia, in my opinion.
Okay. Representative Hong.
Thank you, Mr. Chairman. Thank you for your testimony. I don't do any closing, so that brought a lot of clarity. And I understand, based on your testimony, you, in general, just do not want this to apply to commercial closings. But online, is it mainly the issue being that on line 78, be licensed and present in this state, the issue?
No, it's 1 and 2, right?
Okay.
So this contemplates, this is talking mostly, and the UPL opinions are all talking about residential deals. They don't distinguish between commercial and residential, but they're brought in a residential context, right? That's where one lawyer is sitting at a table, and that lawyer is controlling the process. That is not how it works in commercial deals. There could be 6 or 7. There's always at least 2 or 3, and there could be more. Like Mr. Jordan said, you're going to have a lawyer for the seller. You're going to have a lawyer for the buyer. You're going to have a lawyer for the lender. You may have a mezzanine lender involved. You may have an equity participant involved. All these lawyers are going to either be Georgia lawyers, or they're going to hire Georgia local counsel to make sure they're doing everything in accordance with Georgia law, right? And then they're going to send it all to us. But there's not one party that's controlling the closing process. They're all sending us letters, making us contractually obligated as their agent to close the deal in escrow, and then we facilitate all of this. I mean, we could get 50 documents, we could get $500 million wired to us, $1 billion sometimes, because you think you got money coming from lenders, and money's flowing all over the place. So it's not one person controlling the process. It's a team of lawyers telling us how to close it and disperse it. And this 151950.2b just doesn't contemplate that process. Now, it is a huge step to have the ability to rely on documents that are notarized in other states that conforms with that. And that will help us in closing these deals. But we won't be able to close them if you don't change it back to 1 to 4 family residential. And everybody says nothing's changed, it's just codifying. Well, something huge has changed. There is nothing right now in the UPL law that allows any attorney or anyone other than the Supreme Court of Georgia to enforce the UPL provisions. There's certainly nothing in the law that makes it a felony if I close 3 deals. I may not even have anything to do with the closing, but if I'm aiding and abetting the unauthorized closing of real estate deals in the state of Georgia, I'm subjected to a potential felony. That doesn't make any sense. That doesn't make any sense to me. That doesn't exist now. Treble damages for doing this doesn't exist now. A $20,000 or $40,000 penalty does not exist now. The UPL law covers what it needs to cover. And if it doesn't, the Supreme Court of Georgia can do an advisory opinion. In fact, there's an advisory opinion out right now that's up for comment that should be done soon that allows for this electronic closings. We don't even really need to have this from a UPL standpoint because it's going to be covered in the new UPL provision. So respectfully, if you put the 1 to 4 family, then Jim Jordan and my office and Troutman and King and Spalding and all those people can go ahead and keep doing business the way we've been doing it the whole 21 years I've lived in Georgia without having to worry about somebody suing us civilly or an attorney general coming after us and say that we're going to jail. These are sophisticated parties with sophisticated lawyers. Nobody needs to be protected. We're all for protecting the consumer. If you limit it to the 1 to 4, we're all for it. We prefer it said consumer 1 to 4, or that it had a tie to a closing disclosure. But as long as we can limit to the 1 to 4, so we're only got a few kinds of deals that might be a problem, we will support that.
One more question. In your opinion, if we take the commercial part out, do you think it's a good bill?
I'm speaking personally.
In your,
I do not. I do not think anything about this bill is a good bill. I don't think, as a lawyer, I don't want private parties being able to enforce the unauthorized practice of law. I think it's a bad idea for somebody that's got a motive other than protecting consumers to be able to sue any other lawyer for unauthorized practice of law. When this came up before, there was a lot of discussion about that. Personally, I don't think it is, but I can support it if it doesn't materially adversely affect our ability to close commercial real estate deals.
Would you prefer to see lines 109 through 115 struck from the bill?
Which version is this? I've got like five versions. in front of me.
520569S.
Okay, so 109.
109. It's subsection D of 151950.2.
Absolutely. I mean, this was, so part of what happened was.
There's plenty of consequences if things screw up.
Yeah, there's plenty of consequences. One of the interesting things is normally what happens if there's a problem with a notary or something like that in a residential transaction is my company or one of the other companies that does what I do covers it, right? Mm-hmm. Because if there's a defect in the title, we're the ones who are going to end up paying it at the end of the day because we're the ones who provided coverage saying that it was done properly. So personally, I don't think that the consumer needs to be protected in that realm. I do think that the witness-only closings are a problem, and I do think we need to make sure that consumers are protected and Georgia lawyers are making sure that everything's done because we have a lot of these things we have to clean up in our company because they aren't done properly. But I certainly don't think we should add aiding and abetting liability to people who, are just trying to help close a commercial real estate deal or a residential one for that matter.
All right. Representative Evans.
Thank you, Mr. Chairman. What was the name of your company again?
Fidelity National Title Group. We own Fidelity National Title Insurance Company, Chicago Title Insurance Company, and Commonwealth Title Insurance Company.
And where are y'all based out of?
Well, we're based out of Jacksonville. My office is over by the Brave Stadium.
Here in Atlanta?
Mm-hmm.
Are y'all national? You have
We are
offices
national.
pretty much everywhere?
My office closes commercial real estate deals in every state in the country. Got one going in Canada. I've done some in Mexico. We closed $7 billion worth of real estate deals in the state of Georgia last year, and that was a down year, obviously, for us.
And do you work with doing these closings with the law firms that were represented as part of this informal working group?
Yes.
King and Spalding,
Mm-hmm.
Troutman.
So initially I sent a letter that got signed by, if I can find the letter, it was signed by my company, Stewart Title Company, Stanley, Essery and Buckley, which is a good law firm here in town, Seyfarth Shaw, King and Spalding, Evershed Sutherland, two of the main partners at Austin and Byrd, Smith, Gambrell and Rustle, the general counsel for Landmark Properties, which is the largest student housing owner-operator in the country. They're based out of Athens. They signed it. Troutman Pepper signed it. Greenberg Trog signed it. And we would have a whole lot more signatures. But once the bill got changed to carve out 1 to 4 family residential, we all took a step back and said, okay, well, we can live with this. Now, we wanted some tweaks, and that's what we were trying to do at the prior hearing, was just say, okay, this is good, but there's a few places where we could have a problem here. And I think it kind of got off track a little bit there. I think there's an idea that as commercial lawyers, we're worried that somehow we're violating the UPL laws, and that's why we're worried about this. All of us are 100% confident that we are doing everything we're supposed to do under the unauthorized practice of law rules of the state of Georgia. But until now, we've not had the ability of anyone who wants to challenge that and sue us. We've not had to worry about an attorney general coming after us and say we've violated these laws and committed a felony, and we've never, so you can't really take all the unauthorized law opinions and codify them into one thing as if they were one opinion. These were different things where they're talking about specific fact patterns. One of them is you can't have a witness-only closing because it was a residential closing and the attorney wasn't in the room and the paralegal was handling everything, right? So I get that you don't want that. I understand that you want to have an attorney present to make sure everybody knows what's going on in a residential closing. But this is taking it all, putting it into one law with huge penalties, criminal and civil, and it's fundamentally going to change the way commercial real estate deals have to close. And that doesn't just affect the closing lawyers. You see Portman sign this also. So it affects all the big real estate companies in town who now are going to have an extra level of cost, an extra level of complexity, and they're all on the hook potentially for all the violations of this thing anyway. We close tons and tons of Chick-fil-A deals. We probably close 10 a month. Now, none of those people want to be subjected to potential civil or criminal liabilities for either directly or aiding abetting a closing that any lawyer in the state of Georgia feels like violated the UPL statutes. To me, that's going to be an unbelievable deterrent to closing real estate deals in the state of Georgia. Nobody else has rules like this anywhere.
The letter that you mentioned that was signed by some of the law firms that are part of this working group, did I understand you to say that you wrote that?
I did write that, yes. Well, Mr. Jordan had some comments that got put in it too also, but I wrote it.
You had the drafting pen.
I did.
They provided input. So I think it's fair to say that you helped coordinate that working group and get them together.
I immediately, the minute this came out, that day I started emailing, because I'm in a unique position because I work with almost all of the big law firms in town, right? And this isn't a big law firm versus small law firm thing. This is just let's not mess with how things close. But anyway, I immediately started sending the initial version of this bill to every big law firm client contact that I had, saying, hey, we need to be careful with this. This could fundamentally change. So then I drafted the letter. I got it around. We came and we had a meeting. At the very first meeting, we said, we just needed to only apply to 1 to 4 family residential. You go protect whatever consumer you need to protect.
You called that meeting? You
I don't remember
coordinated
who called
it?
We hired Mo Thrash, and Mo set the meeting up. I don't know.
But you were involved in coordinating those firms coming together to come and speak with us.
And in addition to the small group, which is me, Amy Huskins at Dwayne Morris, Jim Jordan, who's right here from Evershed Sutherland, Shelley Willis from Troutman, and we were just a small working group, but there is a email that's probably got 25, 30 of the lawyers from these firms that and then Josh Kamen and Brent Gilfetter from King and Spalding were in the small group, who've been part of this and who've been, frankly, they just kind of stopped being material participants in it because we all thought we were 95% of the way to being protected.
But if one of those witnesses from the informal working group came in here and told this committee that nobody was coordinating them, there was no client, there was no vendor that was putting this together, that would not have been the truth.
Well, it's the truth. I mean, it's just a bunch of people sending emails around.
Well, you just told me you coordinated it.
Well, I drafted the initial letter and sent the initial emails.
It wasn't
But then
organic.
Amy sent a bunch of, Amy Huskins from Dwayne Morris was sending letters at the same time that sending emails to everybody at the same time I was. And at the end of the day, I took the email chain that was my email chain, and then I added the email chain from where Amy was sending all of her emails to into one email chain. And I have been the one who's been updating people, yes.
Thank you.
Representative Silcox.
Thank you, Mr. Chairman. So pursuant to your additional comments, I want to turn your attention to line 143 through 149. I think that's what you're referring to there, that any attorney could basically rat out the others. This would create new causes of action, possibly a lot more lawsuits. So this would also be still a concern of y'all's.
It's a huge concern. I didn't bring it up because when we talked about it at the last hearing, it seemed like there was this conflict between what the legislature can do and what the Supreme Court can do, and there was a lot of discussion about what if we did this, what could we do, what could we do. But if you come right down to it, if you look at line 143 and 144, the Attorney General, any district attorney, the State Bar of Georgia, the Judicial Council of the State, any attorney or any organized bar association. If you focus on organized bar association, that was in this legislation before, and the Supreme Court of Georgia in a case called Greca versus Untitled already ruled that the organized bar association doesn't even have standing. They don't even have standing to enforce unauthorized practice of law. So not only is this still in here, even though it's already been ruled invalid, now we're expanding it to other parties who would have the ability to bring this, including any attorney, right? So to me, I tried not to get into that issue because it seemed to cause some problem before, but I believe all of this is invalid in this section 151958A. And I personally, from what I've read and the research I've done, I don't think any of these remedies would be permissible either. What you could do, one of the main things it's trying to do is stop witness-only closings. The legislature obviously could pass a law saying any person that's not a licensed Georgia attorney can't do a witness-only closing, right? That would be permissible in my opinion. I don't think any of this is, personally.
Thank you.
All right, Representative Kelly.
Thank you, Mr. Chairman. I certainly understand the concerns you've raised about the state bar being able to already go after individuals, attorneys, under the UPL laws of the state bar. But what about participants in one of these schemes that aren't attorneys? Because the state bar has no jurisdiction over them, correct?
Which is why I just said, if you wanted to create a statute that allowed you to have criminal penalties against someone doing these kind of activities that isn't a Georgia licensed lawyer, I don't think that's a problem. The problem is when you start trying to, first of all, codify a bunch of stuff and add a bunch of penalties that shouldn't be there and codify what's already there, which I'm not sure why you have to do that to begin with.
Because we're policymakers and the state bar isn't. We created them. That's why. I mean, I'm tired of people saying that we have no input once the state bar has done something.
But I'm not saying you don't have any input. That's not what I'm not saying you don't have any input. I'm saying that the provision that we talked about a minute ago, the Supreme Court has already said that that party doesn't have standing. So if we're going to expand the group of people that in the legislation have standing, I don't think that would stand up to the Supreme Court.
Are there not other instances in Georgia law where we have individuals who are in the same section of commerce where they're able to bring litigation against another? I mean, I'm an attorney too, and I don't know if we should be treated any different than a contractor or an insurance agent, anyone else.
I don't know the answer to that. I'm a commercial real estate lawyer that just tries to close deals. I don't really do any other type of law in the state of Georgia, so I haven't really, in fact, this is the only time I've ever been a part of the legislative process.
Thank you.
All right, Chairman Smith.
Thank you. To the gentleman from Powder Springs, welcome. You're getting a good baptism by fire here this morning. As we like to say, the legislature giveth, the legislature taketh away. My question to you would be this. Is there a way where we can change the language that a Georgia lawyer has to be in control of the process, but we still allow for the mail process that's used to get these documents where they need to be? I mean,
I think that's possible, but it would take a lot of revisions to this. When if you just put back the 1 to 4 family residential, then we support it, and it's not going to change the way we materially close business.
Okay, so thank you.
I think there is a way to redo it, but I think it's much simpler to just add the language back that came out of the committee last time, get our support. We all go about doing business the way we've done it. You've protected who you think you need to protect on the consumer side.
Okay. I don't see any more questions, so thank you.
Thank you. Appreciate it.
Can I
Mr.
make
Jordan?
one more comment?
Yes, sir.
Chairman Gunter? I wanted to mention two things, clear up two misimpressions perhaps. One is that Mr. Tidwell talked about closing transactions. You know, he's using the informal sense of the word. The actual closing is done by the attorneys. I want to make that clear. You know, they're our agent. We send them a letter that says you can do the following, but you have to do it in this order and only if we approve it. So the title company is an agent for the closing process, but the attorneys are closing the transaction as required by Georgia law and as makes sense. And then with respect to Representative Evans' question, Sean notified us of the bill, but other than that, he hasn't been directing any action that the working group has taken. You know, I would say that 80% of the emails of the working group weren't copied to Mr. Tidwell. It was all done by Shelley Willis, Josh Kamen, Amy Hoskins, and myself. And if anybody, Shelley Willis and I were the leaders of that group. I've drafted every change to the law that's been circulated. So, you know, Mr. Tidwell simply brought to our attention the law. I was just closing commercial deals the way I always do, wasn't even aware that this bill had been introduced. And he brought that to our attention and immediately we sprung into action.
Representative Evans.
Who drafted the letter?
He did the first draft and I made revisions to the letter that was sent around expressing concern and was then joined in by the various law firms.
And who is paying, if someone is paying a lobbyist to represent the interest down here at the Capitol, who is fronting that bill?
I don't know. All I know is I'm doing this on a pro bono basis. I haven't been paid a penny. I'm not looking to be paid a penny. None of the attorneys that are representing any parties are being paid a penny for any of our work. We're doing it as, you know, officers of the court, members of the bar that are concerned very much about the way the practice has occurred and will continue to occur, hopefully.
And the title company, I forget the name of it, but that is the company that is regularly a partner of yours and the other firms that are part of the working group.
As well as other title companies. There are 4 or
Sure.
5 title companies that are involved in the closing process, and Fidelity / Chicago is, but there's First American, there's Stewart, there are other major players that also serve as agents for the closing attorneys to allow the closing process to occur.
Thank you.
Thank you.
Okay, thank you. All right, there's 2 of our members that are heavily involved in this, so I want to take a recess until they get done with their duties in front of Senate Senate rules. And when they get done and are back here, we'll start the meeting back up. So we're going to adjourn temporarily.
Mr. Chairman,
Yes, sir.
I've been told this is probably going to be the last meeting of this committee. Is that
It
accurate?
is.
So is it appropriate before we do this for me to say I've enjoyed working with you guys? Because I'm not coming back.
Absolutely.
And I don't think there's anybody in this room at the table that was here when I first got on this committee. Is that accurate? Was anybody? None of y'all were here. And
I might have been sitting out there years ago when you came on here.
so I'm going to enjoy not having to get up to come to these meetings. But I think I've missed maybe 3 or 4 meetings in 22 years. And when I missed those meetings, I was actually in a hospital bed. And you guys heard my story the other day. And but I did want to at least say thank you for the opportunity to work with you guys. I feel like I'm a lawyer. I'm not a lawyer. So all that stuff that George is talking about, I guess I could go to jail for the unauthorized practice of law. But I don't intend to do that. But I just wanted to say thank you guys for giving me an opportunity to learn a lot. I mean, I've learned a lot. I probably got more experience in law than most of you guys. But I appreciate you. And I just wanted to say that. Thank you.
Well, I appreciate you saying that, and I appreciate the fact that you may not be a lawyer, but you've got a lot of wisdom and experience, and you've contributed a lot to this committee, especially since I've been here. So, yes, sir. All right, we're in recess until I get my rest of my members back. Yeah, yeah. All right, ladies and gentlemen, we're back at it, and I think ready to go forward. So, first of all, what is the will of the committee on this? All right, I got a motion and a second. Well, right now I'm just getting the motion so we can get to amendments. Okay. All right. Any discussion by the committee?
We're going to take some amendments, Mr. Chairman.
Yes, sir. Go ahead.
The first, thank you, Mr. Chairman. I think we've heard some concern just in general about there being any new criminal provision included in this. And so I would offer that on line 109, I would strike lines 109 to 115 in its entirety. And then because the district attorney then will not be involved in this, because they would never had any criminal investigation, I would also strike any district attorney on line and a corresponding comma on line 143. That removes any criminal penalties.
All right, so those two changes, I'm going to call that the Kelly amendment. Okay. All right, and any further discussion on that amendment? I want to get all the amendments up first so we can see what we got. All right, Representative Evans.
Thank you, Mr. Chairman. I just had a question for the author of the amendment. Is there another place in here where there's some consequence for violation if that's
There's civil
gone?
penalties.
Okay, and where's that?
That would be,
143.
yeah, that's in 143.
That paragraph, A.
Okay, thank you.
Thank you. And there's also additional penalties that would be in section 1.6 under the unauthorized practice of law. And that's on line 180. That whole section would be civil penalties.
49-ish, that's where you could potentially have a penalty for someone who's not a lawyer and not subject to the state bar.
Correct.
Okay.
That's why I think that's important, because there are players in the space that the state bar doesn't have jurisdiction over.
All right. Let's see. Representative Silcox.
Thank you, Mr. Chairman. I have two amendments. The first amendment would just be to eliminate the definition of technology provider at line 70. And that term also appears on lines 109, 214, 315, and 327.
So hang on, give me those again. I got up to 214. What was left?
Originally, technology providers defined at line 70, and then also on lines 109, 214, 315, and 327. Oh, it goes, you're right, it carries on to 316. You're correct.
And I would just amendment to that. You won't need it on 109 anymore if we adopt my amendment for the criminal piece, because you'll have a new 109 after that adoption.
And then my second amendment, Mr. Chairman, if I could,
Okay.
would be to add back the original language in the bill at starting at line 59, the very beginning of that line, 1 to 4 residential, 1 to 4 family residential.
Where's that again, Shirley?
It's on line 59. I wasn't finished. And then on line 61 as well, at the very beginning of that line, 1 to 4 family residential.
What was the other, the second one? The second?
Yeah, it's just
Oh, down there, 61.
It's 59
Gotcha.
and 61. And that may not, does that not fit with the new?
This is a draft.
Oh, okay. Oh, you know what, that doesn't fit with the new bill, so let's just put it at line 59, 1 to 4 family residential. It doesn't work with the language, the way the bill's changed, I'm sorry.
Okay.
No, it doesn't.
All right, that's the Silcox 2, and Silcox 1 was the striking of technology provider definition on line 70, and then everywhere else in the bill.
I'll second that.
All right.
Okay. Okay, he wants it. We're arguing about adding it after.
When we get to a discussion on it,
Okay,
we'll
I'm
talk
sorry.
about it some
I'm
more.
sorry.
Let y'all hammer that out.
Yeah,
All right. Representative Hong.
Thank you, Mr. Chair. On line 78, we're going to strike "and present," and then add a B2 and add language for only 1 to 4 residential closing, comma, be present in this state at the time of such closing, colon, semicolon, and then replace the 234 to 345.
I'll second that amendment.
You got that? All right. Any other amendments? Okay.
Mr.
Vice
Chair,
Chair.
I do have an amendment, and this is very similar to Representative Silcox's amendment, but on line 60, after other than and before real property, add 1 to 4 family residential. Therefore, it would be added back in both sentences of subsection 2, like we voted on a few weeks ago.
Okay.
Chairman, I have a question.
Yes, sir.
So I had understood that was already included in Shirley Silcox.
Which mic are you on?
Another number, 16.
All right, go ahead.
I had understood that was included in Shirley Silcox's amendment number 2.
As long as it's clear.
Okay.
I just want to make sure it's exactly like it was a couple weeks ago.
I just want to make sure there was not another line to which she was going to add that phrase. Okay, thank you. Thank you, Mr. Chairman.
Yeah.
Yeah.
And I'll withdraw it if that's everybody's understanding, that Representative Silcox has had it in both.
I wasn't sure I heard a second on yours anyway, so,
I'll second hers.
yeah. We had that on hers. All right. I think we have it covered. All right. Discussion on these, let's see, let me ask this first. The gentleman that has testified before, do y'all want to come up and comment on any of this? And both mics are live.
Yes, thank you.
Sure, come on up.
Thanks, thanks, Chairman Gunter. I would, as I understand the amendments, as long as all of the amendments are made and it's not a, some made and some not made, I would personally be in favor of those amendments. I think it takes care of my concerns if all 3 of them are made, all 3 of the amendments are made.
Okay.
I think as far as we're concerned, the biggest issue is changing the definition of real estate closing to have the 1 to 4 family language that was in it before in there. All for taking out the criminal penalties and getting the other service providers out of the legislation, but the Representative Silcox is the one that is most crucial to us.
Okay, all right.
Same.
Same? All right.
Actually, I'm in agreement as well. As long as we get the definition changed, the other 2 amendments aren't as important.
That's the main one.
All right. Representative Kelly.
Yeah, thank you. Isn't it true that there's going to be two approaches to how we try to address what I thought the stated concern was, which is not making you be physically present in the state? Because Representative Hong's amendment would make clear that you don't have to be physically present in the state for anything besides 1 to 4. And Chair Lady Silcox's amendment, doing it in the definition, would not only exempt you from being physically present in the state, but it also shield you from any of the UPL violations in Section 1.6. Is that correct?
We're not trying to be shielded from UPL violations. We're trying to make sure that the legislation as passed doesn't have a material impact on the way commercial closings occur.
Yeah,
And I
so
don't think just saying that you don't have to be present in the state does that. It's not one lawyer closing a commercial real estate transaction. There's going to be a lawyer for the seller, a lawyer for the buyer, a lawyer for the lender. If there's an equity participant or a mezz lender, all these people are going to be Georgia lawyers or hire local Georgia counsel. But there's not one lawyer that's overseeing the closing. Everybody is sending directions to us as escrow agents saying, here's my letter. You can close this when you have this deed in this form, and you have the mortgage in this form, and you have all the money, and I have emailed you that you have authority to close. There's not, and each lawyer's representing a different entity in the closing. So there's not one lawyer that's responsible for closing the entire transaction. It's a group of lawyers telling us, once you've met all the conditions of all the lawyers, that you can close it. So I don't really think just changing the presence requirement does what has to be done in order for us to continue to close deals the way we close deals.
May I interject on the presence?
Yeah, I need you to get into the mic here.
The issue on presence, and I think what everybody forgets is you don't have to be sitting there handling different transactions or having people come to you from China or wherever you were talking about, right? What you have to do is you assemble and put together all the documents from everyone here probably has done commercial real estate at some point. Those documents come in from lots of different places and lots of execution. The presence requirement was intended, it needs to be a Georgia lawyer that does adopt it. So you not only bring it to you, you review it, you hold it in your files, and you're accountable to the state of Georgia. And so you can be in Georgia, but you don't have to be the one handling and doing everything. That's really all that presence requirement is for being in the state of Georgia, as opposed to being in California and doing all of this stuff. And I don't know that you disagree if you're bringing it back home. I mean, that's really all it is in that what you're talking about. So.
Okay.
Can I make one comment as well on the representative's proposed amendment to line 7980? I don't think if we have the definitional change, if we change the defined term of real estate closing, as Representative Silcox had proposed to exclude residential, then I don't think we need the change on line 79, because if you look at the lead-in language on B, an attorney conducting any real estate closing, and real estate closing would be defined with Representative Silcox's amendment to exclude residential. So I don't think we need to bifurcate between residential and commercial on line 79, because line 79 is only going to apply to real estate closings, which is limited to residential if the definitional change is made. Hopefully I didn't confuse too many people with that circular statement.
Okay. Chairman Leverett.
Thank you, Mr. Chairman. For the witnesses, my understanding then of the presence requirement is you're intending that to apply to an attorney acting as the settlement agent, not necessarily an attorney just representing one of the parties to the transaction.
Correct. Yes, sir.
Okay.
For my purpose. Yeah.
Okay. Thank you. Thank you, Mr. Chairman.
All right, let's see. Thank you, gentlemen. Well, hang on.
Thank you.
Keep your seat. I've got a clarifying question. All right. So if we vote for Representative Silcox's amendment and Representative Hong's amendment, y'all are okay with the bill? All right. If we vote for Representative Hong's amendment but not Representative Silcox's amendment, are you okay with the bill?
No.
Thank you.
All right. Which is Kelly amendment. All right, Kelly amendment. We have,
That's correct, Mr. Chairman.
all right. Okay, we had a motion and a second. Any further discussion on that one? Hearing none, all those in favor say aye. Aye. Any opposed? All right, that one's added. Forget who we had next. Okay. The Silcox amendment, this is the elimination of the definition and the term technology provider throughout the bill.
So we voted on Kelly 1 and Kelly 2.
Mine was all just one together.
Okay.
Right, I understand what you're saying, but yeah, it covered the whole thing. Okay. All right. Any further discussion on that amendment? The Silcox amendment? On the technology provider strike? Hearing none, all those in favor say aye. Aye. Any opposed? All right, we have that one on. I believe that brings us to Ms. Hong.
No, Silcox number 2.
Silcox number 2.
Add that 1 and 4 in line 59 to 60.
Show me again. Oh, in 58. Yeah, here we go. Silcox number 2, which is the addition of the 1 to 4 family residential language in lines 58 to 61. I believe it went in 2 places.
Real property.
On the,
Real property, no places.
right, on line 59, right in front of the real property right there, and then on line 60, inserted 1 to 4 family in front of real property. Okay. Any questions about that one? Any discussion about that one? Representative Kelly.
I just think there creates a concern, Mr. Chairman, that there's new penalties in section 1.6 for the unauthorized practice of law. In making the change that way versus Representative Hong's way will create 2 different, quote unquote sticks. One that would be applicable for unauthorized practice of law for commercial transactions and one for residential, and that's why I'll have to oppose the amendment.
Representative Reeves.
In addition to hearing to the former opponents who say they would be okay with the bill, with making that amendment, as well as the gentleman who was asked for the bill, I've heard during this hearing with people who are watching it, who are concerned. They're commercial. They're asking if it ain't broke, don't break it. I support Representative Silcox's amendment in the interest of having a good bill.
Representative Evans.
To ask for clarification, Mr. Chairman, or to whoever can answer this, what lines exactly are we talking about right now?
59 and 60.
And this is the 1 through 4 issue.
Yes.
Okay. Sorry, I thought we had gotten to everybody was kumbaya, and then apparently not. So that's what I.
No, there's not on this.
Kelly's.
I think there's kumbaya in the audience. I don't know if there's kumbaya in the committee. Gotcha. So we're just, yeah.
All right. Any further discussion? All right, I'll call it. All those in favor of the Silcox number 2, say aye. Aye. Those opposed?
No.
Noes have it. It's defeated. So that brings us to the Hong amendment. This would be on line 78, striking and present. And was that all of it?
Inserting, and then insert Line 2, Chairman, to state for 1 to 4 family residential closing, comma, be present in this state at the time of such closing, semicolon. And then change the rest of the paragraph numbering to 3, 4, 5.
Oh, that was an insert of a new,
A new number.
gotcha, okay. Right after 1, the first one? Okay, a new 2. All right, everybody understand the amendment? Any further discussion on that? All those in favor of the hung amendment, say aye. Aye. Any opposed? All right. That is all of the amendments that I believe I have. Any further discussion on the bill as amended? Hearing none, all those in favor say aye. Aye. Any opposed? All right, the bill passes. You're opposed. 1 opposed. All right, the bill passes. All right. Thank you. I think we're adjourned. This should be the last appearance of the Judiciary Committee this session. So.
All right. Good year.